topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, welcome to another Ask the Expert show. We're here in rainy South Florida today. If you would like to call into the show, you can call us at 561-623-9429. That's 561-623-9429. Today's show is brought to you by the law firm of board certified Tina Leward. She is a family law attorney out of Boca Raton. You can call her at 561-544-6861. This is the first Thursday of the month. That means K. Bender Rimbaum. They are board certified attorneys in association law. That's community association law. And as always, we have board certified attorney Robert K. Good afternoon, Robert.
Hello, Steve.
You got a lot of stuff coming up this month. We're just looking at the scroll.
One of your favorites is coming up. Plus, we have an Ask the Attorney as well, a live presentation.
I got to tell you that most of this is all free, and you give up a lot of your time to educate clients, people think about becoming a board member. Really, it's amazing, a show like this. But you are here in South Florida. You are also in Palm Beach County. You're in Tampa. You're also opening up an office in Orlando, which we are also running a show. So, you know what, Robert? We get so many new people who some find the show by mistake. They were going through their podcast dials, and some people just hear about our show. Tell people about K. Bender Rimbaum.
Well, as you mentioned, K. Bender Rimbaum is a law firm specializing in representation of community associations, condominiums, homeowner associations, cooperatives primarily, providing all aspects of the services for legal needs of community associations, collection of unpaid assessments, interpretations of governing documents and opinions as to rights and responsibilities of the board and unit owners, enforcing violations of the documents, negotiating with third-party contractors, dealing with the city, construction defect issues, developer turnover issues. Anything an association is going to deal with, those are the legal issues that we provide daily assistance with. We have, as you say, office in Pompano Beach, which is our main office, Palm Beach Gardens, Tampa, and Orlando.
You basically cover the whole state, don't you?
Pretty much.
Although
we don't get up to Tallahassee so much.
Yes, right. But I mean, if somebody is in Jupiter, which we're starting
Palm
to get.
Beach Gardens is just a stone's throw away.
Yeah, we even got a couple letters from Stuart. So we are getting out there, and we're starting to get more from Miami now than we ever have before. So the word is getting out about your show.
Well, we're happy to have everybody listening in and letting us know what their questions are. It's always happy to answer them as best we can.
Well, there's three ways that you can ask your question that has anything to do with community association law. One is right to the right of our screen, there is a chat line there. You can actually go to the chat line and we will take questions from there. We also do a text to 954-336-3767. We put that out there. You can text your questions in, which we get a lot of questions. Or you can just call here during the show at 561-623-9429. And let's get started with the show. Let's go to Rick in Boca Raton. He wrote us, wanting to know, how often are HOA boards legally meant to meet besides the annual meeting?
Well, the annual meeting is really an owner's meeting, not a board meeting, quite typically. The bylaws of the homeowner association identify meeting requirements. The statutes don't set any minimums or maximums. There is an annual meeting of the membership at which the election of the board of directors typically is to occur. Board members usually set a schedule of meetings on a regular basis, be it monthly, be it bi-monthly, quarterly, whatever the board decides they need for the best operation of the association. The board can also schedule special meetings as needed. Oftentimes things come up in between regular meeting scheduled dates that the board would need to meet and take care of, so special meetings for that purpose. But the law does not specify a minimum or maximum on that issue.
And this has happened in all three markets, Robert. People asking, why is there so many statutes for condo but not for HOA?
Well, they're catching up. Condominiums had a head start. The Condominium Act was first put in place in Florida in 1963. Then it was substantially changed in 1972. It went from Chapter 711 to Chapter 718. And it's been tinkered with almost on an annual basis ever since. The Homeowner Association Act didn't come about until the mid-1990s, and that was part of the not-for-profit corporate statute until it was moved over to Chapter 720 some years later. And that is a statute that also continues to be tinkered with and grow every year. They do try to mirror a lot of what they have put into the condominium statute. But HOAs are different in their inherent nature from condominiums. Condominiums don't exist without the statute. Homeowners associations really are just methods of addressing communities that have restrictive covenants in place, and some that are privatized with gated communities and private roads, things that they need a private entity to address. So some of the corporate and procedural issues are set forth in the statute. The major thing that's missing for HOAs from condominium law is the Division of Condominiums. It's a state agency that regulates condominiums, does not exist for homeowners associations. And there is some concurrent jurisdiction there for recall and election disputes, but other than that, HOAs does not have a state regulatory agency that oversees or where people can go with complaints.
We get, I don't they're not really questions at all. We get a lot of emails, Robert, from people who've gone to your certification classes, taken your course. Mm-hmm. But we just recently started having people ask us if you offer an online certification course.
Well, our certification courses that we've been giving since the beginning of the COVID issue have all been online, and we do them most every month. In fact, there's one for HOAs and one for condominiums scheduled this month. They're live and they're online via Zoom. If that's what they're contemplating in the question, that's what we've been doing. We do some in person, but lately most of them have been online.
We have Aaron in Boynton. He's a little concerned. His board, he says, is very unprofessional, only the president talks, and when a resident makes a suggestion, she yells it out, no way, with no discussion or other members' opinions. Is that right?
Well, right and legal aren't always the same thing.
It's true.
Um, in this, from what it's described, it sounds like the situation exists because of two reasons. One, the board allows it, and two, the members allow it. The board generally serves at the discretion of the membership. The membership elect its board on an annual basis, and the membership also has the power to remove board members through the recall process. But that takes an effort by the membership to be involved and participate in sufficient numbers. It typically takes a majority of the membership to accomplish something like that. If the rest of the board is comfortable with the way the president is operating the association, that's evident by the fact that they're allowing it to go on and not taking steps to change it. The board, by a majority vote, can change who the president is at any time, can define the procedural methods that it's going to follow in its meetings and how it's going to operate. Many communities sound similar to what's described here, where there's very few volunteers willing to serve on the board, very little owner involvement in the operation of the association. Board members are there just to serve as a placeholder and rubber stamp of whatever the strong president desires. And as long as the members are sufficiently apathetic and don't take action to fix that, it's going to continue. And there's very little that the law offers to correct that problem.
Okay, we're going to go to Doc in Davie. What is considered slander against board members, and is it the job of the association attorney to sue for slander in behalf of the board?
Well, slander is somebody speaking a false statement about somebody intentionally, knowing that it's false, that causes harm to that individual, that can result in financial damages. And generally speaking, slander is typically a personal claim of the individual board member, not that of the association. Many board members think because they're on the board, that means the association should be bringing a legal action for slander against anybody that says something bad about them. And that's generally not the case. It's not a function of the association to get involved as a plaintiff in a slander case when it's a board member that's been slandered, not the association itself. Slandering an association is a difficult thing to do in the first place, and it's also a difficult item to identify specific financial damages from the slander. If somebody claims somebody's done something of a criminal nature in their slanderous comment, then the issue of damages is not as significant because special damages can be applied. You don't have to prove actual financial damages in that specific situation. But for the association to pursue an action of slander, it's the association that would need to have been slandered, not the individual board member. And the association attorney would not be involved in representing the individual board member in pursuing a slander action. They'd have to get an independent attorney to represent them.
You know, Robert, we get so many questions, and I try to really limit it regarding parking. I just included one tonight is from a unit owner wanting to know, are unit owners allowed to park in guest space instead of their assigned space? If we are finding this out, what should we do?
Well, parking is going to be a community by community issue based upon the governing documents of the community, based upon the physical makeup of the community, what the parking availability is, as well as the policies that have been established by the board in conjunction with what the documents and physical plan would limit. So if there's significant parking available, then it quite often doesn't matter if owners are parking in guest parking instead of their assigned parking space. But it becomes more important when parking is limited and people are all over the place. So it's really going to depend on the community itself. There is no overriding law that applies to this. It really would break down into the documents for that particular community and the policies of the board, which can change.
We're for the people who are viewing, we're scrolling all the different classes you're offering this month. For those on radio and for the podcast, do you have those in front of you, Robert?
I do.
Okay, let's go over those.
Okay, we have a busy month. Starting next Thursday, June the 8th at 12 noon to 1:30 p.m. on Zoom. There's a legislative session update with Michael Bender, hosted by Campbell Property Management, with an update to the recently completed Florida legislative session, things that have been put in place. Some are still awaiting governor's signature to become law, but are likely going to. So that'll be next Thursday from 12 noon to 1:30. And then on Tuesday, June 13th, 9 a.m. to 4 p.m., part of the CAI Gold Coast Expo, there's going to be a 2023 legal update at the PBI Holiday Inn. Jeff Rembaum will be present. It's hosted by CAI Gold Coast Chapter. It's going to cover legislation with a dash of pending new legislation, and there is some continuing education for managers. It's an all-day event, but the legal update, I'm not sure exactly what time that's going to take place, so you can check with the venue on that. On Tuesday, June the 13th at 5:30 p.m. to 7:45 p.m., we're going to have the first HOA board member certification of the month. Alan Schwartzide from our Orlando office will be providing the instruction, hosted by Empire Management. So that's HOA board member certification on June the 13th. There's a luncheon at Carmine's La Trattoria in Palm Beach Gardens on Wednesday, June the 14th from 11:30 to 1:30, and the legislative session update will be a topic there. Jeff Rembaum will be present. It's hosted by CAMU. And then on Thursday, June 15th, we have two exciting events. We have the CAI Southeast Florida Chapter Legislative Update Panel at 12 noon to 1 p.m. Lisa McGill will be participating in a panel of the Florida Legislative Alliance delegates and CAI chapter members to discuss what went on in Tallahassee this last session. And that evening, 6 p.m., your favorite, Ask the Attorney, a town hall Q&A at the Tamarack Community Center with attorneys Michael Bender and Andrew Black. I'm not going to be there, but they are. And there will be some light refreshments available, and bring your questions. There's going to be lots to discuss on Thursday, June the 15th, 6 o'clock to 7:30 p.m. And the last item on Tuesday, June 27th at 12 noon to 2:30 p.m., the Condominium Association Board Member Certification. It's live at the Orlando office and via Zoom. Alan Schwartzide will be the instructor. There's 2 CEUs for CAMs in that. It's certification for condominium board members. And that's what we got coming up in June.
Yeah. If you missed it, you can also go to your website, which is www.kbrlegal.com.
KBRlegal.com.
Legal.com.
Click on the calendar, choose the event you want, and that's how you get registered.
Okay. We're going to go to break. When we come back, we have more with our great attorney. You want to give everybody your phone number also at the office?
Sure. Reach us at 800-974-0680, or you can write to us at info@kbrlegal.com.
So we're going to go to break. We'll come back with more from K. Bender Rimbaum, attorney, board certified Robert K. We'll be right back.
K. Bender Rimbaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rimbaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rimbaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rimbaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
We're back for the second half of the Ask the Expert show. It's now the Ask the Experts TV show. We're here in South Florida. We do the first Thursday of the month with K. Bender Rimbaum. And as always, probably for about the last 6 years, attorney Robert K. joins us first Thursday of every month. Let's get back to our questions. And by the way, it's amazing how many classes you're offering for June. And most of them are all free, right?
All of them are free.
Okay. That is wonderful. And like I said, I've been to the Ask the Attorney, Ask the Lawyer. It ended up lasting for 2 hours. There was a lot of people there. People brought in one question and ended up asking 3 or 4. And I got to tell you, if you're in an association, you can learn so much from that. Let's get back to our questions. This is a condo owner. This is Les in Pompano. He wants to know, how long should it take the developer to turn over control to unit owners?
Well, there's a statutory formula for the turnover requirements based upon the number of units that are sold. And there's typically a formula that's put into the governing documents as well when the developer first creates the condominium. The last of the time frame is, I believe, 90 days after 90% of the units are sold and transferred to third parties. So, it really depends on where you're at. Quite often developers, depending on the real estate market, we see them delaying for whatever reason. If developers are not turning over fast enough for the unit owners, we have assisted in forcing a turnover. That sometimes becomes necessary when, for whatever reasons, the developers don't want to do anything about that. There is a change in the statute this year that shortens the time frame that associations have to make claims against developers for certain construction defects. And it's now possible that a developer delaying turnover can take it beyond the point of what the statute allows, which would in essence leave the association without the ability to bring a claim for those defects. We think that was a problematic change to the statute this year. Not sure what's going to come of it down the road, but that's the situation that we're facing in the near future.
Let's go to Jess in Royal Palm. He is in a condo. Does the new statute state if you are under 3 stories, you still have to fully fund your reserves? Is there a way to waive the reserves?
For condominiums that are under 3 stories, there are certain aspects of reserves that they will be allowed to continue waiving as in the past. The structural type reserves are items that the statute do not allow to be waived, but those tend to apply to the situations that more for the larger above the 3-story association. So depending on the specifics of the condominium, the answer is going to be yes. You'll still be able to waive a good portion of reserves if that's the choice of the community. Now, whether or not that's a good choice is an open question, considering what's gone on in recent years and the recognition of the value that having reserves in place does provide to condominiums.
Okay, let's go to Jack in Coral Springs. I don't know if this question has anything to do with the docks, but if you're contracted with a vendor for, say, painting, and this is a condo, can you wait until the job is completed and inspected before paying them? And what if you supply the paint?
Well, in all likelihood, any agreement with the vendor is going to have a contract, and the contract's going to set forth the payment terms. And typically, you're going to give an upfront deposit, and then there may be payments at certain stages of the completion of the project. What's described might be a situation of a small condominium that's engaging with an individual or even a handyman person to do some painting, and there is no written contract. In that instance, whatever you agree to with the individual is the manner in addressing that. The law itself does not specify, so then it becomes an issue of what your agreement is with the vendor.
I wonder if it's somebody who's been burnt in the past too, with a vendor. Let's go to Joy in Stewart. We were just talking about Stewart. We are in an HOA, a small property. We have a very small gym, and they have cameras in the gym. Isn't there any privacy laws about monitoring people working out? Never heard that question before.
No, there isn't any privacy laws of that nature. If the association has cameras in place, there needs to be some disclosure that they're there, and that the gym is considered a public place within the condominium where there is no expectation of privacy that you would have in your unit. So the having of cameras in the gym is not something that would be legally wrong. We do recommend that there be some indication or notification that there are cameras in place, so that nobody's taken by surprise by that.
I got to read one of our listeners who wrote in, waiving of reserves makes no sense. Not saying I'm Mr. Moneybags, but it'll just cost more later as maintenance gets ignored even longer.
Well, that's a true statement from what we've seen in many instances, that the mindset had always been, I'm not going to be here forever, and these are issues that are going to come up later, and I won't be an owner anymore, so I don't want to pay that now. What owners often don't recognize is having full reserves on hand actually enhances the value of the individual units to a prospective purchaser coming in to see that there is money in place to address these unusual expenditures that can be relatively expensive. And so we try and help people to recognize that, but unfortunately, many people prefer the short-sighted perspective on that, and then end up spending way more down the line.
We actually discussed this next question, but Cynthia in Palm Beach, who is a board member, I promised her because she has sent her question in several times, wanting to know why is there not a state agency to oversee HOAs?
No, we actually talked about that a little bit ago, but
Yes.
it's because the legislature didn't create one.
Okay. Do they need one?
My personal opinion is no, but
Okay.
a lot of people see some benefit in a state agency overseeing. I think that the court system is generally sufficient to address the types of issues that come up in community associations. State agency oversight often can be dealing with issues that aren't all that significant to the operation and create more problems for associations than they solve. Just my own opinion.
Okay. Well, we definitely respect that. Here's Lake Clark Shores. Julie talking about milestone inspection. Does a 2-story, 30-plus-year-old have to have a milestone inspection?
Well, the milestone inspections specifically say for 3 stories and taller. So then the answer to that would be no.
Okay. Let's go to Stephen in Hollywood. What happens when your doc says your year is August 1st till July 31st, but there is no change for the election in the bylaws, and they keep having elections in January to December?
Well, the August 1 to July 31 is a reference to the fiscal accounting year for tax purposes, as opposed to the general operation for election of directors. If the bylaws of the association do not contain specific dates for when the annual election is to take place, generally the board has a discretion to set it when the board considers it to be the best time to do that. So long as it's done once a year, that shouldn't be any legal issue. Typically, the fiscal accounting calendar does not have anything to do with the operation and the time frame for the election.
Troy in Delray Beach, which I know a Troy in Delray Beach, who lives
Maybe
in
that's your friend.
Yeah, wants to know, HOA board member president had a closed meeting telling us what we can or cannot do. Is that legal?
Well, it's not legal to have closed meetings unless it's for a specific purpose of dealing with personnel issues or meeting with the attorney to deal with pending or potential litigation. So closed meetings where a quorum of the board is there and conducting association business would be a violation of the statute in both condominiums and HOAs, as well as co-ops. So that should not be something that is going on. Now, that being said, if the board is having an informal meeting and not taking action and just talking to people about the way things are, that is something conceivably that would not be considered a board meeting requiring notice and owner attention. So that would be not a violation.
Okay. I wanted to get an Aventura listener in, so I took this one out. Ralph in Aventura, what constitutes change in our lobby for material alteration?
Well, material alteration in a condominium is something that the Condominium Act addresses and indicates that there can be no material alteration or substantial improvement to the common elements except as provided in the governing documents. And if the documents are silent, then only upon the approval of 75% of the owners. What is a material alteration has been the subject of a number of cases through the years. But basically, if you're doing maintenance of existing items, and there is a change, while that is a material alteration, there is an exception in the cases that allows the board to make those decisions without having to get an owner vote. But the division has been on record for many years as stating that if you change the color of a wall, that's a material alteration that requires a vote of the owners. And that, in my opinion, was a misinterpretation of a case that the appellate court addressed back in the 80s. But it is the way the division operates. So if the association is dealing with a change that's a change in color, then you got to look to your documents. Now, sometimes the documents say that if the material alteration is X amount of dollars or a certain percentage of the overall budget of the association, then the board can do it without a vote. But if it exceeds those numbers, then they have to go to the owner. Sometimes it doesn't. Sometimes it just says X percent of the owners. Sometimes it doesn't say any requirement at all for an owner vote. So the documents have to be reviewed on that. And it's recommended to contact your association attorney, whoever that may be, to go over the changes that are being contemplated to determine if any of them or all of them are requiring a vote of the owner. It's based upon what you're doing and what your documents indicate.
We just got a text from a listener. They are from, we were just talking about this, they're from Jacksonville. They're visiting down here and found the show. Great show. I'm wondering if the laws that you're talking about for South Florida are the same if I'm in Jacksonville.
Well, these are not the South Florida laws. They're the all Florida laws. So yes, they apply in Jacksonville as well.
Okay. Let's go to Bart in Aventura. Can you comment on documents sometimes say the board can make a material alteration as long as it doesn't exceed a certain amount of money? Is that really true?
Well, as we just discussed, that is true based upon what the documents say. And in some instances, I've seen documents say if the material alteration does not exceed $5,000 and they're changing their paint color from one color to another. Well, the cost of the different colors of paints does not equal $5,000. While the paint job could be $5,000, the actual change is not $5,000. It's the same cost either way. So in that instance, the vote of the owners wouldn't be necessary.
Okay, let's go to AJ in Boynton Beach. If we were granted a request for production of the records, the association has to produce them. Is that right? I should not have to go scan all the documents one by one.
Well, producing the records means here they are, come and inspect them. It doesn't mean here I'm giving you a copy. What the law requires an association to do is make them available to a requesting owner to inspect. And if they choose to make copies, then they can either do it themselves on their own device or identify what they want the association to make copies of and then pay for the copies the association makes.
Okay. Let's go to Merrill in Boca Raton. If a condo board updates or changes a rule or regulation for the happiness of the residents, and it's different from our bylaws, is it legal to do since our docs are 20 years old?
Well,